Greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Coming at you tonight with another presentation on private placement memorandum and discussion. So it's again an open panel. I really hope people will come up and discuss this with me. Otherwise, it's probably going to be a short stream. I've only got a couple things to pull up, but it goes to that very first event where we're born. So before we get into that, I want to remind everybody, please hit that like, share, and subscribe button. And there's a PayPal link down below for anybody that wants to share some love. And of course, the StreamYard link is down there for anybody that wants to join the panel. And since we have no one with us tonight, at this point, we're going to get right into it. And what I did here is I put in a question. Is a United States business able to extend credit? And it says, while it is perfectly legal to extend and receive credit without a credit agreement or credit application, having a formal written and signed document will ensure, and like I've said many times, it's an insurity, it's an insurance scheme, where that endorsement that you're giving is qualified as an amendment to an insurance policy. And so then it says that both you and your customers understand each other's duties and obligations and the consequences of not following through with them. So what we have is an enumeration at birth, which is a formal, written, and signed document that both you and your customer understand each other's duties and obligations, where in that first founding document, that is not quite so. Because if it was, then that document wouldn't be processed as abandoned after a certain period of time and then filed and registered with the state. See, when it's filed and registered with the state, it becomes a public issue. So what we're going to talk about is a private placement memorandum. And that's what I've been saying is missing element at the enumeration at birth is a private memorandum, placing that legal establishment in the hands of mom and dad until that minor child reaches the age of majority and can then make a decision as to whether to be able to conduct that that United States citizenship as a business for the United States as a resident, or choose a private life. So let's continue on. It says, what does it mean when a business extends credit? Many businesses extend credit to their customers. This means that the business provides goods or services to the customer without requiring payment right away. In other words, it's a deferred payment. Okay? We have the right to create a obligation of debt and defer its payment. The customer then owes the business a debt. So if you're operating as a business, who is the customer? Remember that United States citizen is a United States business. When a business could extend credit to its customers, building trust is incredibly important. In other words, it's integral. It has integrity. It has to have that binding element that keeps its strength. Otherwise, it becomes weak. Important when extending a credit line to a client. It is wise to start with cash sales. Now remember, folks, cash sales are more than just the Federal Reserve notes. There are other cash items. A receipt is a cash item. And as a cash item, it's a U.S. debt, and you can sell that cash item for its value. When first dealing with a client to start to build trust. So again, all those contracts are effectively a part of a trust. As you gain trust from sales history with the customer, you can start to navigate towards extending a line of credit. What is a company that extends credit to an individual? Remember that term, individual? A creditor is an entity that extends credit, such as a bank or an individual. And what happens is the individual goes to the bank, opens up a bank account, and in so doing, not qualifying the signature properly, the bank has all rights, titles, and interest in the property, all property, which includes the intangible property, which includes the name. So now they have rights to the name because the individual that gave the name with its address and an enumeration didn't know otherwise and handed it all over. While a debtor is the entity that borrows. So again, we have a situation where the bank is not loaning its own funds. It doesn't have funds to loan itself, except those Federal Reserve notes, which are advances, which would presume to be synonymous with loan, but that's only supposed to be for to Federal Reserve institutions, from Federal Reserve institutions through Federal Reserve transfer agents, and for no other purpose are allowed. While, like I said, there are many other cash items like checks, money orders, receipts. What are the criteria for extending credit? Here are a few key steps to follow if you're considering extending credit to some or all of your customers. Determine your financial risk. What's your financial risk if you don't know how to sign the documents, first and foremost, and end up handing over your rights, titles, and interests, even if it be to a customer? Develop a thorough credit policy. I believe that's already established, and all you have to do is follow it. And that's the main problem. 98% of the people don't follow the credit policies. Access creditworthiness of customers. Customize terms for each customer. So if you're going to customize, are you not a customer? Like I said, it's a quid pro quo. If you are treating them as a customer, they get to treat you as a customer in what's known as an equal exchange under negotiable instruments. However, if you don't negotiate that equality, then you give it up. What is the disadvantage of extending credit? Late paying customers. Now, if you have the right to defer a payment, that means you have the right to offset its payment to a later date. But again, that's dealing with them cash items. That physical documentary product, the paperwork, the negotiable instrument. However, in the electronic system, like I said, it converts that cash item to a credit item, storing its value electronically to save any future paperwork. Most of your customers who buy on credit will be great customers who pay you on time. But there could be a few bad eggs that bring trouble in the form of late or delinquent payments. Now, reminding everybody that these payments are payments of debt, which are an obligation or other security of the United States, and that's why they require the signature. So again, it's only while you're operating in a business fashion that you would deal with the credit and debit. Again, when you understand the trust law, then you access it outside of the contract through the trust as a benefactor. Hey, I realize there's a benefit here for me, and I believe under American interests and the international protection of persons, or internationally, as a internationally protected person or holder thereof, I get to place a signature on the instrument. It's duly authorized, letting you know that I'm not liable for the person so named in the instrument. This is qualifying that endorsement without recourse paid to the order of by Benefactor for Keith Orland Little. So anyway, that's the question I posed, and I urge everybody to do that and then go looking through those different responses down the line. Just open them up and see what kind of information you can get to help you determine. Again, this sounds a lot like a purchase agreement from the dealership. When you go down to the auto dealership and they give you a purchase order, and that purchase order is issued by a buyer to a seller. So if the automobile dealer is issuing it to you, you're the seller. What are you selling? Quid pro quo. They're going to sell you a document, and equal exchange, you're going to sell them credit, so that that documentation can be entered into the electronic book entry system and circulate the credits. It cuts off the circulation of the documentation, which is in accordance with the Paperwork Reduction Act. You don't need paperwork anymore. Just correct the electronic data elements. So let's look on to the next one, and that's that private placements. Again, when you're born, that enumeration at birth produces a security instrument that is then presumed to be abandoned because mom and dad never put it in a private placement holding until that child, minor, infant, whatever, becomes age of majority. It can make that decision for himself. That's effectively estopping the criteria of being a resident and actually using that United States business and putting it in holding until it can be organized appropriately under the laws of the United States, so that it is not used against the one that plans to use it or would be able to use it. Again, you don't have to. You can create your own persons. And it says here, private placements. Broker dealers that recommend or sell private placements have additional requirements under FINRA and SEC rules. Filing certain offering documents and ensuring the suitability of any investments they recommend. So everything, again, is an investment. That security is an investment. And like I said, mom was the informant in an investment that started an investigation. That's the vital statistics record. And it's going to investigate you all of your life. It's going to keep track of you all of your life. An individual who owes a debt to the United States. Well, if you owe a debt to the United States, again, quid pro quo, the United States owes you a debt. And if it's a debt on one side, it's a credit to the other side. So you both owe each other credit and debt, if that's the case. Again, that equal consideration, equal benefit. It's a simple contract term. It says filing requirements. Oops, where'd I go? 2 FINRA rules require firms. Now, again, that's that conversion at the local county courthouse under the administrative courts, where they changed that last name to a firm name, which is the all uppercase letters, the first 4 letters of your last name. So instead of putting down Little in all uppercase and then the first name, they put down the firm name, which is Litt in all uppercase with no L or E. And then they put a comma, first name, Keith. So what they did was they converted the legal name, which is Keith Little, to a firm name, which is Litt, which is actually a stock ticker indicator for a collection of pooled bonds in those names that are then, because they can't place each individual bond in that name, they're pooled collectively and placed in a different name, the name of the county, in the county registered investment system or court registry investment system. to file certain offering documents. And when mom and dad fail that, it fails the offering. Mom and dad didn't offer it as a possibility in the future and accept it accordingly to allow the child to make that decision when he became age of majority. It was abandoned. So the state took it and filed it, and information about the issuer. Who issued it? The hospital. The birth clerk is the one that issues it. Just like the county clerk is the one that issues the bench warrants and things like that, all the documentation. It's the clerk that issues them. The judge orders them, or administrator orders them, but the clerk issues them. So in the hospital, it was the doctor, pursuant to doctor's orders, that the birth clerk issued that original certificate. And if you remember, I've spoken on this a couple times. I'll mention it again. In my experience, I found out that doctors actually have more authority than the administrators through the courts. Now, you can believe me on that or not. It's up to you. I urge you not to. But again, because it's my firsthand experience that I tell you that. And I'll explain it in detail sometime, but we're just going to let that be known. I know firsthand that these doctors do, in fact, have a greater authority than the administration. So let's continue on. It says, FINRA Rule 5112, member private offerings, requires firms, let's finish the first sentence, I guess. The offering terms and firms selling the private placement with FINRA. See, that's essentially what you're doing is you're selling a private placement with the local courts. It's a private investment. So their court registry investment system then turns around and converts that last name to a firm name. Just like the Social Security and the Centers for Medicare and Medicaid Services, they get the Social Security number and then convert that number for their own filing system. So under your, like in Iowa, it's Iowa Total Care gives you Medicaid. So under Iowa Total Care, they use a different number that is attached or launched to the Social Security number. So all of your insurances are run through your Social Security. That's all they're doing. They're just matching up their records. So FINRA Rule 5122, member private offerings, requires firms that offer or sell their own securities or those of a control entity to file with the Corporate Financing Department a private placement. Otherwise, these courts take it as a public placement because you're claiming a resident, a federal, state, or municipal officer or agent. You have to quit that. And it says a private placement memorandum. This is the memorial that I was talking about at the birth. Mom and dad are supposed to put forth a memorial. And on that, greetings, Iman. How you doing tonight?
All is well.
Good to hear. Good to hear. And do you have anything to say on that memorial at birth? I mean, have you had children yourself?
Yes, I have had children, yes, but I'm not really too familiar with it, so I had a question earlier, but I'll listen to what you have to say and become enlightened. I thank you.
Well, no, go ahead and ask your question real quick.
Oh, well, you already covered part of it earlier, but I will listen in and become enlightened. Thank you.
Okay. Okay. Appreciate it. So it says, and then it goes on to say term sheet. Remember contract terms and conditions? The term is a span of time. And just like contract with time, the term is the time span. So with time, time span, or other offering document at or prior to the first time the documents are provided to any prospective investor. So again, that goes to the abandonment. So if mom and dad don't take the date of first sale of a private placement by making that private placement memorandum themselves, then that's considered an abandonment of a security instrument, and the state takes it and secures it themselves. That's done at enumeration at birth, 10 days later, I believe, in most states. If it's not claimed by mom and dad then, and that's why the file date is at least like 10 days to 30 days later, sometimes even longer. So, the next one, FINRA Rule 5123, is private placements of securities. If you're not a member that can make a private offering, you can still do a private placement of that private security, because that's truly what it is. It's a private security. Requires firms to file with FINRA's corporate financing department within 15 calendar days. Okay, so they're saying 15 by federal law. State codes might have it 10 days, I don't know. But 15 days of the date of first sale of a private placement memorandum, term sheet, or other offering document, or indicate that no such offering documents were used. So basically what they're doing is going on the presumption of the establishment of that legal business. That's as simple as it gets, folks. And if you don't claim that business as a mom and dad and hold it in safekeeping, in compliance and agreement with the United States, knowing that it's a gift, and as trustees help protect that gift by not allowing anybody to confuse your legacy heir of how it's to be used, even him. And again, that's the problem. The public education system doesn't teach us about any of this stuff. It doesn't teach us, as we're developed as a United States business under that United States citizenship, how to run that United States business and how it qualifies under organizational rules to be a United States business, and the qualifications of being able to represent that United States business in an administrative court. None of that happens. And again, that goes to the strength of this nation. I really urge people to think twice about whether this nation is as strong as it poses through the education that seems to only be an average of 7th or 8th grade reading comprehension. I think that's distasteful. I think that's just idiotic. Do you really think that a bunch of 7th and 8th graders can run this country? No. And if you think that the country is being run by people that have a greater education than that, then what is the greatness of that education, and why is it being used against you? I mean, this is obvious. It goes on to say that firms also must file any amendments or exhibits to the offering document with the corporate financing department within 10 days of being provided to any investor. Okay, so there's a 10-day one. The information filed with the corporate financing department is subject to confidential treatment because it's a private placement. And if it's not done as a private placement, then it's a public placement, and it presents a presumption that it's not confidential. And that's why all those agencies get information access to your data elements. You're the one doing it. You're the one allowing it. And again, it's only because you don't know this stuff. So again, it's not entirely your fault. But again, as adults, we need to educate ourselves to a higher degree. Knowing that this situation that we have with the public education system, particularly in these modern times, showing the insanity of not just the transgender institutionalizing in our own children, but the abuse that goes on, the alcoholism, the drug use by teachers and faculty themselves. If you really want to help with that, quote, war on drugs, and don't want your children coming up in that kind of environment, and you're not a drug, you're an alcoholic, then please keep them at home. These public environments are not good for them. For crying out loud, they even found cocaine in the White House. Firms should submit offering documents as searchable PDFs via the private placement filing system in the FNRA gateway. Please note 5122 and 5123 notifications are notice filings, giving legal notice. And remember, the first duty in law is legal notice. Mom and dads have failed that first duty in law for a long time, and that's what's saying that that United States business isn't operating correctly, and that's why they're penalizing it. And in that penalizing that United States business, even though it's a internationally protected person under the American interests, you have been authorized to act as a trustee or a benefactor. And no, again, nobody's taught you that in this public service, which is a public trust, that you're not the public agent and that you need to qualify yourself as that benefactor to the beneficiary. Nobody's taught you how to run a United States business, so why would you step into that capacity? Yet that's what everybody's doing by signing these commercial documents. As such, FINRA will not respond to the filings with a comment letter nor provide a clearance letter. Okay? It's a private thing. Filing resources, private placement filing system user guide. And let me get this up real quick. Let me copy and paste this so that everybody down there can look this up and go from there. Inform yourself on what the difference is between private placement and initial public offerings and how this securities exchange system works as far as a trust operation. Again, if you are the benefactor to the beneficiary, you're the one that's actually giving them the data elements, which goes to the record, which is the beneficiary. They then use that beneficiary record in the electronic system to forward credits. You get the same access to be able to direct where those credits go to, so long as you know where they're coming from. And that's the problem. Nobody understands that they're coming from themselves. In each exchange, you have an equal consideration. If they're demanding money, then you get to equally consider the option of granting an extension of credit. Pure and simple. Frequently asked questions regarding private placements, firm guidance, private placement filings, instructions for requesting entitlement to the information requests application in the FINRA gateway. See, that United States citizen is an entitlement. It's all uppercase. It's a title. That's entitled. Compliance tools. Filing timeliness report summary. Again, that's that 10, 15 days that you're supposed to file those things. Otherwise, it's considered abandoned. Now that it's abandoned, it's property, abandoned property held in abeyance until a rightful claimant comes forth and makes a valid claim. And that's all we're doing. If the commanding officer shall cause receipts to be issued, and that's that birth certificate that you order from the state and they give you a receipt. The spoliated owner, having not pled, may use the receipt to obtain indemnity. So you are in receipt of a security instrument with 2 seals on it, providing for the full faith and credit. You can take that through a directive for full acquittance and discharge to release all credits back to the remainder back to the estate in a private placement. Now you have the credits, and that private placement is with the Treasury and the Postal Service. Treasury operates on the administrative side. Postal Service operates on the judicial side. And again, this is not legal advice. This is my presumption that I'm putting forth as an accord to my research. And again, don't believe me. Don't believe the neighbor. Don't believe the government. For crying out loud, don't believe your mother. Do your own research so you can know. I can explain it to you. I cannot comprehend it for you. Due diligence and suitability. This is in order to be able to file a suit in the courts. That's what suitability is. Suitability is the suitability to be an employee as a United States citizen running a United States business. And again, if you're not suitable, then you cannot be taken into those administrative courts because you don't have a board of directors to hire an attorney to make such a legal representation. Texas Rule of Civil Procedure, Rule 12. FINRA will examine firms' private placement activity to ascertain whether firms are conducting a reasonable inquiry of the issuer and offering. Has anybody conducted a reasonable inquiry of the issuer and offering? See, this is your due diligence. You have to conduct a reasonable inquiry of the issuer and the offering. And again, like I said, folks, when you do your research, you find things out. And I am telling you again, don't believe me when I tell you, the clerk is the one that issues. That's the one that you go after. That's the one that's converting the cash forms, the definitive documentary forms, the definitive paperwork into an electronic book entry system which belongs to the Postal Service. The recent Regulation D amendments do not alter a firm's responsibility to conduct adequate due diligence on its offerings to ensure any recommendations to purchase securities in a private placement are suitable. And this is what I'm talking about when you're supposed to lend unto the nation, because as long as we keep allowing these people to place a debt against that estate, that's creating a debt against the United States. When we take control of it and prevent that debt from being placed by using the credit extension system, it's a circulatory system that does not create a debt against the United States. Again, it operates that quid pro quo. If I'm going to extend credit to the United States through that United States instrumentality, then it's merely a recognition that I accept their credit in return, because that's all we truly have to give each other. I don't have any of my own kind of physical money to give them in exchange for their physical money, which is Federal Reserve notes or even coins. I do have silver I can melt down and make my own coins. But again, it would have to go through a postal service for the weight of the silver, because that's the monetary value, not in these dimes, nickels, quarters, and pennies that we have today. That's a decimal system. If you remember the thing the other night about the decimal system, that doesn't work properly according to regular math. And that's their whole thing, decimal, 1%. Firms must also understand their obligations to comply with Regulation B.I. in connection with its due diligence and suitability responsibilities. So again, according to the laws of the United States, in order to be a United States business organized under those laws, you have to have a corporate body. You have to have documentation with a communication with the Federal Reserve, acknowledging that documentation, putting forth your bylaws, your corporate structure, and of course your board of directors. And if you don't have that stuff, then you can't run a United States business. You can only be a benefactor to it and hand it back to the United States so that they can ensure it is internationally protected on the American interest side, making sure that all accounts are balanced with the general ledger. Registration with the SEC and exemptions from registering. Under the Securities Act of 1933, any offer to sell securities must either be registered with the SEC or meet an exemption. Issuers and broker-dealers most commonly conduct private placements under Regulation D of the Securities Act of 1933, which provides 3 exemptions from registration. Under Rule 504 of Regulation D, issuers or firms may sell up to $5 million of securities within a 12-month period. So at the state level, you can order 10 birth certificates a year. You can put $500,000 value on each one of them, and sell it to the United States government in exchange for the balance of money or its equivalent, so deposited, especially wherein they have already given credit or are now obligated to give credit. 12 U.S.C. 813, 12 U.S.C. 204.2, definition of deposit. As holder in due course, of course. Under Rule 506 of Regulation D, issuers or firms may employ general solicitations and advertising when offering private placements, provided that all purchasers of the offering are accredited investors. This goes to Article 9 of the Lieber Code. Oh, come on. Wherein it states, the functions of ambassadors, ministers, or other diplomatic agents accredited by neutral powers. First, let's pay attention to that, because if you remember, the Judicial Officer Department is a neutral and independent forum within the United States Postal Service, comprising of the Judicial Officer, the Administrative Law Judge, and the Postal Service Board of Contract Appeals. To the hostile government, cease, so far as regards the displaced government, but the conquering or occupying power usually recognizes them as temporarily accredited to itself. So again, I ask, why would they be violating a United States citizen or resident by saying that United States citizen or resident owes a debt to the United States? It just does not make sense. And then, of course, let me skip down to Article 38 to show you under Section 2 when it regards public and private property of the enemy, protection of persons, and especially of women, religion, arts, and sciences, punishment of crimes against inhabitants of hostile countries, private property, unless forfeited by crimes or by offenses of the owner, can be seized only by way of military necessity. There's that word necessity again, saying that that federal, state, or municipal officer or agent whose resident presence is deemed necessary. Again, recognizing that the Selective Service is responsible for all administrative and operational support of the board or local of the one or more local boards within its jurisdiction. Again, it's a military zone for the support or other benefit of the Army or of the United States. If the owner has not fled, the commanding officer will cause receipts to be given, which may serve the spoliated owner to obtain indemnity. So now that you have that security instrument as holder in due course, you get to enforce the rights of indemnification by stating the amnesty that's already there in that Treaty of Berne protecting literary and artistic works, Article 1, Section 8, Clause 8, the creative or the power of the creator in its authorizations and authorities and things like that. That was Mom that created and gave that family name and given name. That's the original creation. That's the intangible property that they are taking advantage of through that signature when you don't qualify the proper capacity of that name. And we've got JG and Jim Brasfield that joined us. Good evening, guys. How you doing tonight? Anybody? Good. Good to hear you, Jim.
You, man. Football's good.
Staying warm out there, JG? I noticed you've been wearing a thick jacket here lately. I think you're breaking up. We'll keep you in the back. We'll keep you here. Um, just let us know if you have anything to say, guys. So let's get back to it here real quick, because I ain't got much longer to go here. So the accredited investors are yourselves. They have to. It's equal consideration. If you're going to give accreditation to the laws of the United States and give them qualification as if though they're true and effectual and apply, then you have to be able to apply them correctly, and that's an equal consideration. Firms may conduct other forms of private placements using exemptions other than those allowed by Regulation D. This is the venue of equity where you get to create your own remedy. You get to create your own exemptions as long as they're plausible and reasonable. And real quick, before we get any further, um, issuers or firms may employ general solicitations and advertising when offering private placements. So this one up here, I related to selling it back to the United States, okay, in the equal exchange of that value that you put on that documentation and in exchange for a remainder of credits that already exist, simply by reconciling the record to make sure that it balances with the general ledger. It should show credit still existing. Okay. Under this one here, you get to offer that private placement to other agencies. Say you want to have your medical record included in certain statistical researches, you can let them use that information in their statistical records by making it a private placement and allowing them to use those records, those data elements confidentially, and therefore anytime they use them it's like a royalty fee. You should get compensated because it's attached to the intellectual property that belongs to you, and if they're going to use that name, then you get compensated. This prevents them from using the name in any fashion, even if they want to make a claim against you later on. I'm sorry, now you have to pay me for my royalty on that name. Even if you want to take it through the administrative courts, and the administrative courts will recognize that, and guess what that shows? Shows I'm the authority. I'm the one that gets to use that name, not you. I already set my terms. You want to use it that way and then turn around and come back after me? You better be very succinct in your language because I'm going to catch you up. I'm going to show you that that was nothing but a United States business, and it has nothing to do with me. It has to do with the usufruct system, and your claim against that entity is a claim against the United States. Are you allowed to do that in their own courts? Were you ever allowed to go home when you were a little kid and make a claim against mom for not making you a righteous fucking dinner? Instead, she made you mac and cheese and hot dogs. Did you have that right? No. The same thing here as adults, people. You need to start learning how to adult and protect yourself. That's the basic issue. Chosen, you're there, but your device is saying it says device not connected, and it looks like we lost Jim and JG. And with that, we are done with tonight's presentation. So, what do you think so far, Iman?
What did you say, brother?
So, what do you think so far? Do you think we absolutely made a mistake in many venues in not sending in sending our kids to these public education centers, in going to hospitals and giving birth and all this without truly knowing?
I think that we have because it was because we know not what we do or have done. And the only reason I say that because I remember an elder that in a community setting where everyone, all the families knew one another, um, there was several elders who took the names of children that came into the world and they were written into the Bibles. Everything was written into the Bible. The arrival of the child, or a date of baptismal, or any particular special date, it was put into a Bible. And I still don't really know because I never thought about it till you mentioned today. At least two of the elders that I remember, they passed on, they ascended, but I never knew what happened to their Bible. I know one of the families still have their Bible, and they still continued the tradition of putting information within the Bible.
Yeah, and
You
that's
know,
I remember that specifically myself. And my brother is, just a side note here. My brother is doing life in prison in California. Now, I don't know much about his life, but I do know at one point in time, before he got convicted out there for that particular sentence, he was screaming as loud as he could to everybody in the family that he wanted that family Bible that we had, and that technically it was his because he was the firstborn son of my father. But the problem is, my father was not the firstborn son of that family. So they had an issue with trying to give him that family Bible, particularly since he was on his way to prison. But the concept was that that family Bible showed his name in that family Bible and would prove that the state really didn't have any jurisdiction. Now, whether he could pose that at that time or not, I don't know. I know I can, but I still know that even if I can pose it, they may not think much about it and still lock me up anyway. But that those are the boots that I stand in, and those are the times and places that I'm willing to go forth in, and have the fortitude to know that I'm doing it alone. That if that happens, I don't have anybody else's support. I don't need it. All I need is God, and that's my sacrifice. I
right.
cannot bend my knee to this commercial system anymore.
The question that I do have, Keith, I remember one day I was doing some banking. That's before all what I know now. And there was a woman who came into the bank one day and she brought her Bible with her. And a lot of her information was written into the Bible that she
Yeah,
had.
that was,
And
see,
she,
them Bibles were the actual original trust instruments. That's how
right,
people were able to apply for that public trust, is show that they were spiritual people and this is their register. It held
right.
all of
But
their family information.
exactly. But the question she had that was really unusual, and I was not really trying to get into her business, but she was speaking loud enough. She wanted to know, was there a way that she can get pages within in the Bible that stuff was written for the family notarized? So that's the question I posed to you.
Well, yeah, and that's one of the intricate things about the scriptures. A lot of people say it's the law, that it's banking knowledge. I use it as psychological knowledge. And when and when we realize that that Bible is actually telling us about how to use our past history and the honor of the people in our family that came before us, we truly do pay for our father's sins, but we can also uphold our forefathers' honors, and that's what's falling us. We're falling to that thing about paying for our father's sins, or believing that we were born into this debt. No, we were born into a debt system. We were born into a sinning system, but we were not born debtors or sinners. We were born children of God. Why would God bear us into a world and call us debtors? As an image and likeness? I don't find that credible. I find the credence in the Word of God, the Word of truth. So that's why I do this research. And Tribe says, can you do a margin call on it? And that would be determined by a forensic accounting to find out if that interest is lower than the going rate for the broker. And so again, the actual premise isn't necessarily doing a put call or a margin call or anything like that. It's a matter of reconciling the record because we know, in fact, it is in error through these definitions and these regulations. That was a private placement. Again, um, That was a private placement under a state's vital records, um, vital statistics in the United States, users, system, and sources of revenue, which is a current birth registration process for a state vital records jurisdiction. They use that as a source of revenue. It's a revenue from private to public. I mean, you can't get any clearer than that in the basic language. I mean, that's plain writing. Current birth registration process for a state vital records jurisdiction, source of revenue, revenue. And again, that's that military jurisdiction that says the police or the martial law chiefly affects the police and the collection of public revenue and taxes. And yes, certificate is only an abstract copy of the original record, which at one time, like I said, was the family Bible. Now they use that informant, the statement of live birth at the hospital, and that's the problem. That's the document we're not supposed to be doing. We're supposed to be making a private placement of a private register showing that we have authority. We do have a village to raise this child. This child is not abandoned.
Question that I have, brother, just quickly. Um, as we're talking about the Bible and we're talking about registration, when
Dear,
someone
can
gets
I
a
ask you real quick?
registration,
I noticed it myself. Can you come closer to the phone? You have
yeah,
a very,
I'm close enough to the phone. It seems somehow my volume it gets distorted somehow, but I'm as close as I can be. Is it
all
better
right.
now?
Nope, but go
Okay,
ahead.
well, anyway, the question that I have, as far as the birth registration that we're talking about and in the Bible, when something is recorded in the Bible and you have it within your possession, you are considered the holder in due course of that, um, the book or the or instrument, correct?
Absolutely.
So,
That's the purpose of holder in due course is knowing what you're holding and how to enforce it. That's the right
oh,
of a holder in due course is to enforce the instrument. So if you go to the hospital with that family Bible and that register in it, that's your right as holder in due course of that instrument. Like I said, it's a trust instrument to enforce it. And that's the private trust already established through a legacy of multiple generations.
so can one holding that particular instrument or the book, what's called the Bible, could one denounce that by sending notice to these statistical um,
Absolutely.
places and say, I'm in control of my own destiny through the Most High, putting everything written within the Bible as tradition as I was taught to do. So now I'm sending you notice for you to remove or resend any electronic filings or record that you have, uh, for not my for the person where you're using my name or my calling to be removed out of your system. Would that be the right thing to do? I mean,
Right.
I'm
And it's
just
a matter again of correcting the records only. You're not going to make any threats or try to coerce them or anything. You're just going to give them simple facts, and if they follow it, they follow it. If they don't, you've given them notice. You keep record of that, and that way, if they try to come at you and say, "Well, no, you didn't," yeah, I did. I gave you notice, and you ignored it. That's misprision of felony. So anyway, Tribe says the family Bible is the original record of birth, not a certificate. Correct. The certificate is the document that certifies that the original record of birth is true and correct. And again, that's the problem. You're supposed to be able to get that memorial birth certificate that I think they call it uh, a hearthside in some states, but it's a memorial birth certificate where they actually have your footprints on it. And you're supposed to be able to put that in your Bible and give them that equal consideration of the private placement. See, now I've got that record in here, and it's not going to be established until he turns 18 and can connect this record with that record with this record. See? Just like the founding documents of a country. You've got to establish your independence, your the way you conduct yourself, and the rights and obligations thereof.
Just a quick thought. It crossed my mind. You were mentioning about the instrument that's given to the mother when the child is born, where they have an imprint of the footprint. Now, within the pages of the Bible, can't a living man or woman create their own and also have a
Absolutely.
document of that within? Okay,
Absolutely.
okay.
I know many people. I've done one myself even after the fact. I did it years after the fact. But even that creation, it's my creation, and they can't deny it. You can even go through the paternity papers, the child support court situation, the custody situations. Every last document they have proves that my document, my birth certificate, even after they created theirs, has more authority than theirs because it came from the originator. I'm the one that planted that fucking seed.
So, Keith, I would say that any authority that living man and woman has would be from their authorship in the documents or instrument that they create within themselves in an original state.
Yep. It's your authorship. Again, Treaty of Berne, which protects literary and artistic works, and Article 1, Section 8, Clause 8, that correlates with that, protecting those same rights of the author, upholding them superior to all others. And with that, we are done. It is what it is TV. Go look them up and go check them out and subscribe if you think they're putting out good content. Love it. I'll see you here shortly. We're wrapping up my stream. I'm going to go join him. And you folks, in the meantime, remember, don't believe me, don't believe the neighbor, don't believe the government, and for crying out loud, don't believe your mother. Learn how to do your research so you know and understand. I was the bitch ass slave. I was the dumbass fool for many years, just like most others are now. I too was caught up in that cognitive dissonance. I too was caught up in the ego and the pride. It's time to grow up and be full grown boys and girls and understand that if you really think you've been duped, if you really think this United States is operating against you, then get up and learn how it's doing that. You got anything on the way out, Iman?
No, I only thing I say, all praises to the Most High and to my brothers and sisters that is walking this same journey with me. It is what it is.
Absolutely, and that's what I like about you, sister. It's not about me leading or being any kind of teacher or guru or expecting anybody to follow me. I'm looking for people that want to walk together because that's truly what it takes. And like I said earlier, though, when it comes down to the final straw and I'm the one that gets thrown in that jail for this or that, I understand already myself that that's my burden and I don't put it on anybody else out there. I don't expect that the information that I've learned from anybody along the way has been imputed as they did it for me. I'm doing all of this myself, and that's the recognition that everything in my life, all those documents I signed, I did it. Even though I did it unknowingly, I still have to take responsibility, and that's the utmost concern. It isn't until then that you will get up off your ass and learn how to change it. Otherwise, you're going to keep blaming everybody else. And so with that, we're done. And you guys know I love you. I don't give a rat's ass whether you love me back. And that's to say, I don't care if you don't love me. I don't care if you hate me. I don't care if you don't respect me. That's all on you. So may God bless you and have a good night.